First up, we're at the Pierce County Courthouse in Tacoma, Washington, where a hearing for an unnamed Level 3 sex offender is underway. Level 3 sex offenders are classified as posing the highest threat to public safety. The courtroom's nearly empty. In the back, 2 courtroom deputies appear to be carrying on a casual conversation. In the front of the room, a judicial assistant works on her computer. The defendant, who is uncuffed, appears calm, sitting next to his lawyer. Everything seems pretty casual. And then this happens. Out of nowhere, the defendant rushes toward the judicial assistant. The female deputy springs after him from behind, while her partner heads in the other direction. The defendant lunges at the assistant, who, along with other members of the court, quickly flee the area. The deputy catches up with the defendant and wrestles with him as he smashes a computer monitor, before finally being slammed to the floor. Her partner arrives to assist. The defendant is subdued and then cuffed. A few moments later, several deputies arrive and haul the defendant into custody for destruction of property. It's unclear why the defendant seemingly went after the judicial assistant. Fortunately, there were no injuries, and the total damage was under $1,000, as the fast-acting deputy ensured the only thing hurt was a computer monitor. Next, we're in Las Vegas, Nevada for an arraignment hearing.
City versus Joshua Martinez.
Joshua Martinez is representing himself after being charged for driving with a suspended license.
On the charge of having a suspended driver's license on April 12th. What is your plea, sir?
Just I have a couple questions before we proceed. I don't understand the nature and cause of the charges.
Well, you're charged with driving on a suspended, canceled, or revoked driver's license.
Sounds pretty cut and dry. Well, not to Martinez, who apparently wants to dig into the legal details.
Okay, is there a sworn statement against me or injured party?
I believe you probably received a citation on April 12th. That would be the criminal complaint filed against you.
Okay, and is there a injured party or damage to property here against
It's charge brought by the city of Las Vegas, sir.
Okay, so the city's the victim in the case?
The city is the, yes,
Victim?
the charging.
So they're the victim.
Whatever direction Martinez is trying to take things, Commissioner Ann Elworth is not going there.
What is your plea on
If the
charge?
city
Mr.
is
Martinez,
if they are the
today is your-
victim,
Mr.
I would like
Martinez,
to
I am in
move
charge
this
of
to
this
a federal
courtroom, and
court.
you're going to stop
No,
it.
we are in charge of the courtroom.
It may be called the People's Court, but the judge is about to show who's actually in charge here.
Marshal, would you show Mr. Martinez the inside of our holding tank, please? You're not going to tell me who's in charge of my courtroom, Mr. Martinez. Go ahead and go with the marshal. That is direct contempt of court.
You are in contempt.
Martinez is temporarily removed from the courtroom. Then, about 20 minutes later, he's brought back in to be sentenced for his newly acquired contempt of court charge.
Okay, Mr. Martinez, since you have informed me that I am in contempt of court and that you are in fact in charge of this courtroom, I'm going to go ahead and sentence you today to direct contempt of court. I will give you an opportunity to apologize if you choose to do so and behave in a manner that I consider appropriate for a courtroom. Would you like to do that today, Mr. Martinez?
What would I be
It is a
apologizing?
yes or a no question.
What would I be apologizing
For
for?
your direct contempt of court, sir.
All I was asking was legal questions, ma'am.
I disagree, sir. I'm going to ask you the question one more time. Did you wish to apologize and proceed in a manner I consider appropriate in this courtroom or not? Okay. Direct contempt, I'm going to sentence him to 15 days in jail. Okay, thank you.
The Sixth Amendment grants me that.
Sir, I would suggest you stop speaking now.
Martinez would be jailed for 15 days for contempt of court. His original charge of driving without a license was later dismissed. We head to Dallas, Texas for a civil hearing. 33-year-old Amanda Stiles and her ex-husband Ryan Parnell are in a child custody dispute. Parnell's attorney, Lacey Kimball, has filed several motions with the court, which include a request that Stiles take a drug test. Today, both parties appear remotely before Judge Drew Tenike to review the motions. Stiles appears without an attorney.
Good morning. How are you all?
Morning, how are you?
Morning.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
Stop talking.
Things get off to a rocky start.
You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
The judge remains calm as Kimball continues.
We also had sent discovery out as laid out in our motion sometime back. We ultimately never got a response.
We got plenty of responses. Objection.
Hold on, wait a second. Ms. Stiles, you just need to object, and then let me know what your objection is. Don't yell at her.
Objection to hearsay.
Hold on.
Judge Tenike presses the mute button on Stiles, allowing Kimball to speak without interruption.
And then we have an order to compel Ms. Stiles to provide dates for a deposition.
All right, so Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond.
Despite her disruptive behavior, the judge moves forward, attempting to get Stiles' responses to the 4 motions in question.
Do you have an objection to taking a drug test?
I use marijuana daily. All day, every day.
Okay.
So I'm glad to take the drug test.
Stop.
Okay, go. It's going to be on his expense, but I'm
Stop. I'm pretty low key. We're in court. You need to be respectful. Just say Judge Tenike. Okay, it's pretty easy. So you use marijuana all day, every day?
not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tenike.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
I'm not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. What's your response to their motion to compel?
Have you read their discovery?
Ma'am, you need to answer my question.
I answered your question.
All right.
By now, even this low-key judge seems to be losing patience.
So I'm going to warn you that it is completely inappropriate to swear like that in court.
Stiles then pushes her camera away.
You need to take yourself, you need to put yourself back on camera. I'm gonna sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it.
Judge Tenike tries to get back on track.
In terms of the deposition dates, what's your response to that?
What date?
Ms. Kimball, do you have proposed dates?
And whose expense? Mine? Because if it's mine, I'm not doing it. Sanction, give me $100 fee. Whoop, whoop.
So I am finding you in direct contempt.
Okay, one fine.
Finding you $100.
Okay, make it 2. Damn. I said 2 words.
Ma'am, I don't think you want to do this. I will, as I said, sanction you.
Please do.
Before ending the hearing, the judge tries to get a deposition date on the books.
Which of those dates works better for you, Ms. Stiles?
What time, dumb? 3 contempt.
You're correct, that is 3.
Supposed to start at 9 a.m.
What date?
That question is to you. Never mind.
I said what
I'm
time?
not gonna let you
Time,
finish.
date? You know, these
I'm not
things.
gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that as another violation.
Stiles was held in contempt and ordered to pay $400 in fines. As for the child custody case, Stiles later relinquished her rights to the child, including any visitation rights, and the father, Ryan Parnell, has full custody. Next, we head to Sanford, Florida, where closing arguments are underway in the trial of Antonio Rosales. Rosales is accused of dragging a 10-year-old girl off the street and into a wooded area, where he reportedly assaulted and raped her. The defendant is described as a drifter with a violent past. Assistant State Attorney Anna Valentini is delivering her closing argument when Rosales, through a translator, vehemently objects. Seemingly insulted by being labeled a child molester, Rosales grabs a keyboard and smashes the computer monitor on the defense table. Two officers attempt to restrain him, slamming him to the floor.
Please take the jury as a police constable. Platform will be open. I need to take your badge and to go through.
Meanwhile, Judge Deborah Nelson seems as though she's struggling to open a door,
I can't open that door.
so she calls for some help.
I need the deputy.
But Rosales is not done fighting. Finally, with the help of additional officers, Rosales is cuffed and then carried out of the courtroom.
Everybody calm down. We'll take it to the
Judge Nelson suspends the trial for the evening. The next day, the jury finds Rosales guilty of kidnapping, attempted murder, and sexual battery. He receives 3 life sentences. Next, we're in Shelbyville, Kentucky for a divorce hearing. The husband in the case has filed a motion that would require his ex-wife to secure her prescription narcotics inside the home where she lives with the couple's 3 children, aged 14, 16, and 18.
They're old enough and they're wise enough not to go around taking, I only interviewed the children for a few minutes, and I get it that they're okay with not taking. Your children are very bright, and I can't even believe you would make that motion.
Judge, in all due respect, I can appreciate what you're saying. They are good children, but there has been some mental health concerns, and we just think it's good practice to do that.
The attorney is reminding Judge S. Marie Hellard that one of the children expressed thoughts of suicide during his parents' divorce. But when she's still not receptive to the motion,
It's not a 2-year-old who'll pick up a pill off the floor.
the father does not hold back.
Your opinion on that, I'm sorry, is just wrong. Intelligent children die of overdose just as well as unintelligent children.
You have no evidence to put before me that these
that
children.
is-
Oh, listen, you need to stop talking.
All right, I'm
You
sorry.
really do.
I disagree with you on that.
Well,
These are the
fine,
li-
you disagree,
this
but
is
you're
the
not
lives
up
of my
here.
children.
I've ruled on that.
Frustrated, the man makes a quiet comment under his breath.
We're ridiculous.
But apparently it wasn't quiet enough.
You're in contempt of court. You don't tell me that I'm ridiculous. Do you understand me? Have a seat over here, bailiffs. Take him and have a seat back there. And Mr. is not going to come in here and bully me. Not going to happen.
But under the watchful eyes of the bailiffs, the upset father continues pleading his case.
My lives of my children are at stake here, Your Honor. You heard yourself that one of my children talks about committing suicide. Yeah, they're in a house full of narcotics that are unprotected. Do you not see that that could be an issue?
For a moment, it appears the judge might be reconsidering the father's argument. Then again,
You don't know what's going on in her house a bit more than a man on the moon.
ultimately, the motion to have the prescription narcotics secured inside the home was denied, and the man was sentenced to community service for contempt of court. Next, we're in Las Vegas, Nevada, for a pretrial video hearing. 65-year-old Thomas Randolph was previously found guilty of 2 counts of first-degree murder and 1 count of conspiracy to commit murder for having a hitman kill his wife and then killing the hitman himself to cover his tracks. Randolph would successfully appeal the case and get his conviction thrown out based on the state's mention of a piece of his criminal history that was ruled inadmissible. As a result of the Nevada Supreme Court's decision, he's now facing a second trial. As it approaches, Randolph has some issues to address during this pretrial hearing.
I have some problems. I've been trying to get with the lawyers, and they tell me that the prison will not let them visit me virtually, will not let them talk to me telephonically. That is what you guys told me, correct? It's my understanding you're the judge, you write the orders, they do what you tell them, not what they want to do.
After making what sounds like some reasonable requests, Randolph begins making some not so reasonable requests.
This is nonsense. I'm not going to put up with this much longer. So I'm asking if my lawyers file an order asking me to be transported to their office so that I can access the computer and go over the files because they have the files. You would certainly sign that, I would believe.
And that's going to be a hard pass for Judge Tiara Jones.
I'm not going to sign an order to transport you to your attorney's office because that's outside of my jurisdiction. That is up to the prison where you are transported. So you're incorrect, and I'm going to sign that.
This is nonsense. I want the hell out of here. It's getting old. So you have to step up and make these people do what they need to do. And lastly...
But before he can issue his next demand, the judge shuts him down.
And this is...
Mr. Randolph, you can't dictate when the lawyers are going to come visit you, okay? These lawyers are going to come visit you when they can arrange to come out and visit you. I am not going to sit here and guarantee you that that's going to happen on July 10th. Because then if it doesn't happen, then we lie. Mr. Randolph, when I'm talking, you're not.
Later, when given another chance to speak, Randolph uses his airtime to boast about how he'll soon be walking away a free man.
I know what I know, and this case is over. And I know when these lawyers see what there is to see, they're going to file the appropriate motions, and they're going to ruin your day, and they're going to ruin the state's day, because then you are going to grant these motions that they file, and I'm going home. It's that simple.
Thomas Randolph did not go home. At the time this story was produced, he was in custody, waiting for his second murder trial to begin. Next, we go to a hearing in Breckinridge County, Kentucky, where the defendant is not typically the one standing before the judge. The accused is Todd Pate, the former sheriff of Breckinridge County. He's charged with assault, operating under the influence, his second offense, criminal mischief, and leaving the scene of an accident. A year earlier, while driving his personal vehicle, Pate allegedly caused a crash, injuring 4 people. He then left the scene. When he was arrested later that night, his blood alcohol level was nearly twice the legal limit. Pate was released on bond and later retired from the sheriff's office. Today, the 51-year-old's in court to change his plea from not guilty to guilty, a decision he's already agreed to in writing. This will allow him to serve just 75 days in jail versus a possible sentence of up to 15 years if he went to trial and was found guilty of all charges. To make it official, all he has to do is say the words to Judge Janet Crocker.
At this time, is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement?
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
And then is it your intention to enter a guilty plea at this time or not, sir?
No.
Mr.
Why am I wasting your time,
Mr. Chambers.
The judge ignores the question and checks in with the prosecution.
Why am I wasting your time,
Mr. Chambers, what is the Commonwealth's position at this time, sir?
Your Honor, we would move to revoke the defendant's bond at this time.
The judge orders a brief recess, perhaps hoping Pate's attorney can remind him he's already agreed to plead guilty. Back in court, the judge tries again.
Let's get back on the record and see if we can sort this out. At this point in time, what is Mr. Pate's decision with respect to his guilty pleas?
So I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred.
The problem is Pate doesn't agree with the assault charge and believes the prosecutor only added it because of Pate's position as sheriff and because Pate rejected an earlier plea deal.
I feel like I'm being very much bullied into doing something that's not right. And I want this court to know that Todd Pate holds himself responsible for everything that he did. It's hard for me to lay down and plead to felony charges that don't apply.
By this point, the judge has heard enough.
Is it your intention today to enter this guilty plea?
And if I could address...
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny. Let me just plea and get it over with for everybody. Plead to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
Pate's attorney looks frustrated, while the judge is fed up with Pate's flip-flopping.
I think we're done. At this point in time, I think we're done. Where I think we are today is that on the one hand, the Commonwealth can enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry. I'm sorry.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He will be taken into the custody and housed in the Breckinridge County Jail.
Your Honor, if I may speak to Mr. Chambers' motion to revoke the bond.
I've already ruled. I've already ruled at this point in time. We're done at this point in time. He's going into jail today.
Pate eventually pled guilty and accepted the terms of his sentence. 75 days in a county jail with credit for time served.
Jeremy DeWitt. Did I say that right? Yes, sir.
41-year-old Jeremy DeWitt is charged with carrying a concealed weapon. The Orange County Sheriff's Office is very familiar with DeWitt.
Oh, God, not him again. It's Jeremy.
Since DeWitt's been arrested several times in the past and convicted once for impersonating a police officer.
What are you doing? What the f does it look like I'm doing, dog? Get the f over before you find out. Stop pretending you're a police officer.
DeWitt runs a security company that provides escort service during funeral processions. But he has a long history of using this business to drive recklessly through traffic, block intersections,
Go past me! Go past me!
and confront other drivers when he believes they're disrupting his services.
Hey, pull over! Pull over!
Police eventually caught up with DeWitt, and he was charged in 2 different counties with impersonating an officer and failing to register as a sex offender. He was released on bond, and that's when police catch up with him again, 10 months later. A deputy stops him along with one of his employees when he sees DeWitt carrying what appears to be a firearm.
Don't reach for that firearm! Walk away from your bike! Keep your hands up! Keep your hands up! Go down to your knees! Do not reach for that firearm! You're being secure because you're openly carrying a firearm. What? You're openly carrying a firearm!
It's illegal to openly carry a firearm in Florida, and after he's placed in cuffs, the deputy tries to remove DeWitt's helmet, which the faux police officer does not appreciate.
What are you, dick? Am I helmet? I'm trying to identify you because I can't see you. You're trying to identify me?
When DeWitt learns why he's being arrested, he goes ballistic.
I'm carrying a pepper ball. You already know that. I do not know that. That is a firearm. That is a firearm right now. All right, Jeremy, you're being arrested for carrying a concealed weapon. Concealed? It was in plain view. That's not plain view. That's concealed. That holster's concealed. What are you talking about?
DeWitt is furious with police, and there seems to be only one thing on his mind.
Give me a lieutenant. Give me a lieutenant. It was in plain view. It's in plain view. Give me a lieutenant. Sit down. Sit down and be quiet. Where's the lieutenant? Where's the lieutenant? Where's the lieutenant?
But the real police don't take kindly to his demands.
Give me a lieutenant. This is not right. Are you listening to me? Are you listening to me? I'm a deputy. I'm not an officer. You don't tell me what to do. I understand. Stop yelling at me, and I'm going to stop yelling at you. Do not yell. Do not raise your voice at me. Yes, sir. Do you understand? I understand. You've already asked the sergeant for a lieutenant. You don't get to pick and choose who comes to the traffic stop.
DeWitt's taken to the station and officially charged with carrying a concealed weapon. But when it's later determined it was just an unloaded pepper ball gun.
This online identifies as a Glock, basically a Glock replica. Can you show me on here anywhere, I mean, I don't know why you'd have a light on a less lethal, but can you show me anywhere on here where it gives anybody the idea that this is not a firearm, that it's a less lethal?
I can't answer that. I don't make those. But you know they're less lethal.
No, I'm asking. If I saw this, I wouldn't know that.
That's where you're. But you can say that for somebody else.
Okay.
How's it going, sir?
Good. How are you?
The charges are dropped.
Wherever you want to go. Do you need a ride? Where can I take you?
Isn't it amazing how nice you guys are when you screw up? Thank you. Let's go. Come on.
But DeWitt's far from being out of the woods. Because of this recent arrest, his current bond is revoked. So DeWitt goes before the judge to clarify the situation.
Your Honor, I'm sorry. I was on bond. They revoked my bond with a new charge, but that charge was dropped.
He has approximately 10 or 11 other cases that he's currently enforced.
Oh, you got a bunch of different cases that are keeping you.
Right.
DeWitt's eventually set free with his bond back in place, but will still stand trial for impersonating a police officer, and if found guilty, he could be looking at 5 years in prison.
Thank you, Your Honor. Have a good day.
Yep.
For our next story, we head to Raleigh, North Carolina for the trial of Jonathan Sander.
Specifically planned by him as suggested by the jail phone calls that you've heard in this case, and they are calculated.
Sander's charged with first-degree murder in the killing of his next-door neighbors Sandy Mazzella, his wife Stephanie, and Mazzella's mother Elaine.
He's framed. All right. That's the way it is. And justice will be served.
The Mazzellas and Sanders were friends and business partners until things began to unravel a few months before the killing. Sander was accused of sexual misconduct by the Mazzella's 14-year-old daughter. And according to police, it was these allegations motivated Sander to enter the Mazzella home armed with a shotgun to murder the 3 victims. While speaking to police, Sander admitted he was responsible.
I know it was me. I know I did whatever happened. I know it was me.
Even with this confession, Sander pleads not guilty claiming he was set up and that the real killer is Sandy Mazzella's father. And during the trial, Sander wasn't shy about sharing his other opinions regarding the killing.
There was no blood under it.
Mr. Sander, please be quiet.
It's fact.
Mr. Sander,
They didn't
please.
look at
Mr. Sander.
And what were her last words?
What everybody else did that's watching us.
Whatever.
No blood under that wound.
Mr. Sander, please be.
This is my life involved. I was frank.
Remove him from the courtroom, please.
Remove me from the courtroom.
Hey, stop it! Hey. Yeah.
Throughout the trial, Sander continued to lash out.
And
You're telling me I blasted
Mr. Sander, get him out of here. Get him out of here. Get him out of here. Mr. Sander, Mr. Sander.
After a trial lasting several weeks, a jury comes back with a unanimous verdict.
We, the jury, by unanimous verdict, find the defendant, John Frederick Sander, to be guilty of first-degree murder of Sandy Mazzella, guilty of first-degree murder of Stephanie Mazzella, guilty of first-degree murder of Elaine Mazzella.
Sander's convicted on all charges, but he's not done speaking out.
I did shoot Sandy. I barely wounded him. After I left, Sal Mazzella shot and killed his family. Why? For insurance money.
When Sander was finished, it was Superior Court Judge Graham Shirley who had the final word.
I want you to realize that if you live out your life expectancy of 25.1 years, that 2-minute period is going to have to repeat itself 6,578,000 times before you take your last breath. And when you take your last breath, you're going to die alone and you're going to die forgotten.
Jonathan Sander was sentenced to life in prison with no chance of parole.